Hello and welcome to the Kenneth Verkaman Law Office Legal Podcast. In this edition, we talk about advanced directives and living wills. All states have declared that competent adults have the fundamental right, in collaboration with their healthcare providers, to control decisions about their own health care. States recognize in their law and public policy the personal right of the individual patient to make voluntary, informed choices to accept, to reject, or to continue alternate courses of medical and surgical treatment. Why should someone have an advanced directive living will? Modern advances in science and medicine have made possible the prolongation of the lives of many seriously ill individuals without always offering realistic prospects for improvement or cure. For some individuals, the possibility of extended life is experienced as meaningful and of benefit. For others, artificial prolongation of life may seem to provide nothing medically necessary or beneficial, serving only to extend suffering and prolong the dying process. States recognize the inherent dignity and value of human life, and within this context recognize the fundamental right of individuals to make health care decisions to have life-prolonging medical or surgical means or procedures provided, withheld, or withdrawn. States recognize the right of competent adults to plan ahead for health care decisions through the execution of advanced directives, such as living wills and durable powers of attorney, and to have their wishes respected, subject to certain limitations. Now, what's the purpose of the advanced directive? Let's see. Well, one of the purposes of the advanced directive is to make sure that your doctors and your family know your wishes. So in order to assure respect for the patient's previously expressed wishes when the capacity to participate in activity in decision making has been lost or impaired, the living will also will facilitate and encourage future sound decision making in the process. What are the requirements of the statute? The Advanced Directive for Health Care, living will, requires that a writing be executed in accordance with the requirements of state law. In New Jersey, it must be either signed and dated in front of an attorney at law or other person authorized to administer oaths, or in the presence of two subscribing adult witnesses. If the two adult witnesses are used, they must both attest that the declarant is of sound mind and not under undue influence. A designated healthcare representative shall not act as a witness to the execution of the advance directive. Since this is a legal document, it must be executed properly to be valid under the statute. Now, what's a healthcare representative? The declarant must designate one or more alternative healthcare representatives. The healthcare representative means the person designated by you under your living will for the purpose of making healthcare decisions on your behalf. When does the advance directive become in effect? The advance directive becomes in effect when it is 1. Transmitted to the attending physician or healthcare institution, and 2. It is determined that the patient lacks capacity to make a particular healthcare decision. Treatment decisions pursuant to the healthcare directive, living will, shall not be made implemented unless there has been a reasonable opportunity to establish, and where appropriate confirm, a reliable diagnosis for the patient, which shall include the attending physician's opinion concerning the nature, cause, extent, and probable duration of the patient's incapacity. Now, let's say someone has a living will that was done many years ago. It's recommended that that living will be changed because of what's called the Health Information Privacy and Protection Act, the HIPAA law. And this HIPAA law was enacted by the federal government in a way to protect the rights and information of seniors. But this federal law, the HIPAA law, was adopted to require the written release and consent of authority of healthcare providers before medical information could be released to the agents, family members, and interested persons of the patients. So basically what the HIPAA law said was that mom could have been brought to the doctor's office for 10 years by the daughter. The daughter paid the bills, discussed everything with the doctor. But once the HIPAA law took effect, it's federal law, the doctor could no longer explain to the daughter what medical treatment was needed or even discuss anything. So, the effects of the HIPAA law are far-reaching and can render previously executed estate planning documents useless without properly executed amendments or new documents. So, there's probably a recommendation that there be new living wills, powers of attorney, and certainly all medical directives. They all should have a HIPAA paragraph. So powers of attorney and living will should be updated to reference this new law. More information on the HIPAA law can be obtained through the articles on living wills and advance directives at the website www.njlaws.com. To have a living will advance directive prepared, power of attorney or will prepared in New Jersey, contact the Law Office of Kenneth Verkaman, 732-572-0500, 2053 Woodbridge Avenue, Edison, New Jersey, 08817. On the web at www.njlaws.com or centraljerseyelderlaw.com. Thank you.